Just So the next issue we have is the LA County Mental Health Courthouse project. So we're here to talk about the updated plan for the LA County Mental Health Courthouse project. So,
Mr. Chair, Kirk Child from the Judicial Council. This is a one-time request for $44.6 million from the SB 1407 account that would fund the renovation and expansion of the Los Angeles Hollywood courthouse. This would replace the existing Los Angeles Mental Health Courthouse. And as part of this request would be a reversion of $32 million that's already been appropriated for site acquisition. We'd no longer need to acquire a new site. So the benefit now of moving to the renovation of the Hollywood Courthouse will certainly save both the costs and time. So overall estimates are about $50 million in cost savings for this approach on the courthouse.
Okay. Report from the LAO.
Anita Lee with the Legislative Analyst's Office. We have no concerns with this proposal.
Department of Finance. How about any public comment on this item? None. I just had one question. Where is this courthouse located in LA County?
It's about 8 miles from the existing mental health courthouse, and I'm trying to remember it's in Hollywood. Sorry,
Hollywood.
it's in Hollywood Courthouse.
On Hollywood Boulevard,
Okay.
right by the freeway, yes.
Okay.
Yes.
Yes.
Near Howard. Okay.
Easy access for the sheriffs, we're told.
Okay, good. Well, with that, again, we're going to have to hold this open as we get my other two members back and be able to vote on this. So thank you very much. And so now we'll also talk regarding the new East County Hall of Justice.
Yes. This is a request for an appropriation of $39.1 million from the SB 1407 account to complete the financing for the state portion of the Alameda new East County Hall of Justice project. This proposal recommends that funding a portion of the project through a loan from IGNA as a substitution for what was previously going to be used for county bonds. This approach, we believe, would end up saving about $20 million in the costs of this project to the state, and I think remove some risk that, although somewhat remote, but remove some risks that would be posed through bond financing that I think Department of Finance could speak to.
Okay. LAO's report?
We would agree that the cash option is the better proposal.
And Department of Finance?
Yeah, Brian Dewey, Department of Finance. I would just note that, we worked extensively with, bond attorneys and real estate attorneys and going through the transactions and just determined that the cash option is ultimately just a much better way to grow for this project.
Okay. Any public comment on this item? Seeing none, we'll have to hold this one open as well.
Thank you.
Thank you.
Thank you.
This one's going to make no, we can't do it. Okay. Okay, our next item is the Judicial Branch budget update.
Would the chair ask that legislative analyst lead
Yes.
off?
LAO, go ahead and report.
Great. Anita Lee again with the Legislative Analyst's Office. So committee staff asked us to prepare a handout essentially that summarizes our analysis related to the proposed augmentation to trial court's operational funding. So in this, we'll provide a little bit of background on where we are, what the augmentation would mean, and then finally end with our recommendations. So first, turning to page 1 of the handout, we provide a summary of prior year budget actions. Since 2008-9, the trial courts have received a series of ongoing general fund reductions that have totaled $724 million by 2012-13. However, the 2013-14 budget did include an augmentation that reduced the total ongoing reductions to $664 million. Most of these reductions were offset by using revenues from special fund transfers, increased fines and fees, and trial court reserves. Despite these offsets, trial courts still had to absorb $215 million in general fund reductions in 2013-14. Trial courts have taken various operational actions to accommodate these reductions. You've heard of some of them in terms of closing courthouses or courtrooms, reduced clerk hours, etc. While the impacts of these actions vary across the courts, some of them have resulted in reduced access to court services, longer wait times, and courts being unable to complete workload in a timely manner. Turning to page 2 of the handout, we take a closer look at the governor's budget proposal. The governor's budget for 2014-15 proposes an ongoing general fund augmentation of $100 million to support trial court operations. If you look at the rightmost column on the figure that's before you on this page, starting at the very top, in that first section, we see that the proposed augmentation means that the ongoing reductions that the trial courts face are further reduced to $564 million. Moving down that column, we then see that the budget assumes that $249 million in resources will be available to offset those reductions. This leaves $315 million in reductions that the courts will need to absorb in 2014-15, which is a net increase of $100 million over the amount already assumed to have been absorbed in 2013-14. Excuse me. The budget also requires that the additional funding be allocated based on the new workload allocation funding methodology, better known as WAFM. However, trial courts would have flexibility in spending these funds after they were allocated. Turning to page 3 of the handout, we provide a brief summary of WAFM, this new funding allocation methodology, because it does have an impact on what the augmentation means to individual trial courts. So prior to 2013-14, funds appropriated for trial court operations were allocated to the individual trial courts on a pro rata basis, generally based on the historic share of statewide funds they had received. In April of 2013, Judicial Council approved the use of WAFM, which is a new funding allocation methodology that's generally based on workload. Beginning in 2013-14, WAFM will be implemented in phases over 5 years with an increasing portion of existing base funding allocated using WAFM rather than the old methodology. Additionally, any augmentations not designated for a specified purpose would also be allocated under WAFM. To the extent that such additional funding was provided, an equal amount of funding that would have been allocated under the old methodology will be shifted to be funded under WAFM. So then, turning to pages 4 and 5 of the handout, we identify 4 challenges that the trial courts will face when addressing the ongoing budget reductions. First, there are increased employee benefit costs. In recent years, the administration has expressed concerns about how effective trial courts have been at containing their employee-related costs. Accordingly, the administration has not proposed additional funding specifically for increased trial court retirement and benefit costs since 2010-11. According to the judicial branch, these cost increases will reach an estimated $64.1 million by the end of 2013-14. Without additional resources, the trial courts will need to use more of their operation dollars to fund these costs. Second, there have been few statutory changes to increase efficiency that have been adopted to date. In May of 2012, the judicial branch submitted to the legislature a list of 17 measures to achieve greater operational efficiency or additional court revenues. However, to date, only 4 have been implemented. In addition, stakeholders have indicated that more efficiencies are possible. In order to effectively absorb the ongoing budget reductions, additional changes to make the courts operate more efficiently will likely need to be adopted. Third, there are fewer resources that are available to offset reductions. Repeated transfers from judicial branch special funds have greatly reduced their fund balances. As a result, any additional transfers would either result in delays to planned projects or reductions in certain services that are typically supported from those funds. Similarly, the full implementation of the new trial court reserves policy, which significantly limits the amount of unspent funds trial courts are able to retain, means that there will be minimal reserves available to help offset the ongoing reductions in 2014-15. Finally, there is limited ability to increase revenues to offset the reductions. Revenues for most of the fee increases that were increased to help trial courts offset their reductions have generally been lower than what was projected. This could be an indication that further increases in fines or fees would not generate as much revenue as we previously achieved. Turning to page 6 of the handout and keeping these challenges in mind, it does mean that the augmentation may only minimize further service reductions. So first, the access to court services may not substantially increase. The governor's budget does not include a list of priorities for how the augmented funds should be spent. Additionally, as we discussed previously, trial courts faced additional cost pressures, and they will have to address an additional $100 million in ongoing reductions, as one-time solutions that were used previously are no longer going to be available in 2014-15. Second, the impact of the funding increase will vary by court. Some courts may have been better at controlling their costs, and this means that they would have more of their augmented funds to use for other purposes. Additionally, trial courts differed in the operational choices they took over the past few years to address their reductions. To the extent that limited term solutions were used and are no longer available, those courts would need to use a greater portion of their augmented funds to simply minimize further service reductions. Finally, as promised, I said we would come back to WAFM. Because the proposed funds would be allocated based on WAFM, courts that have had relatively have historically have more funding relative to their workload would benefit less from the augmentation. Additionally, those courts will be affected by the increasing redistribution of existing base funding as WAFM is phased in. We would note, however, that the reverse is true. Those courts that have historically had less funding relative to workload will benefit under WAFM, and this will begin to correct the historic funding inequities amongst the courts. So then, last but not least, if you turn to the last page of your handout, this is page 7, we leave you with 3 recommendations for your consideration. First, we recommend that the legislature establish priorities for how the proposed augmentation be spent and to require the courts to report on the expected use of the funds prior to allocation and on the actual use of the funds at the end of the fiscal year. Second, we recommend that the legislature consider further action to help the trial courts operate more efficiently. Such efficiencies could help the judicial branch further offset their ongoing reductions. The legislature could even consider convening an independent task force to identify and recommend such efficiencies. Third, we recommend that the legislature take steps towards establishing a comprehensive trial court performance assessment program in order to ensure that trial courts are using their current funding effectively. We would first recommend that the legislature, in consultation with the judicial branch, specify in statute those performance measures it believes to be most important, and to require that the courts report on these measures, will collect data and report on these measures annually. Once data has been reported for at least 2 years, the legislature would then be able to establish a system for holding the individual trial courts accountable for their performance relative to those standards. So with that, we're happy to answer any questions you might have.
With that, we'll move ahead with the Administrative Office of the Courts report.
Thank you very much. Good afternoon, Mr. Chairman, committee members. My name is Stephen Jarr. I'm Director of the Judicial Council's Administrative Office. May I start, first of all, by renewing my thanks on behalf of the Chief Justice and the Council and the branch for this body as it brought to light the severe crisis that our court system has found itself in as a result of these years of recession. The conversation began here. The request to increase reinvestment in the branch began here as well, as did the progress in dialogue between the branches of government. So we're grateful for that, and doubly today grateful to this body because each of its members issued and executed the recent letter to the governor pleading for his consideration to reinvest in our branch. We're eternally grateful, obviously, to you for your willingness to make that important request. At the last hearing of this body concerning the judicial branch budget, I sought to emphasize that the series of requests that had been made by this body of our branch have been addressed, and we have responded to them. You asked us what it would take to have a fully functioning branch for the benefit of the citizens we all serve. The blueprint that the chief has presented is the response to that request. You asked for a method of allocating the resources to the trial courts that is most equitable. Our branch, in concert with the trial courts and the Judicial Council, responded with the WAFM formula, to which the LAO's office has already referred. You asked for specific impacts in each trial court of the cuts that were necessitated by the recession these last years. We responded with the snapshots for each county and each court, which have been updated, as I know the members are well aware. You also required, at the end of the last budget season, that we as a branch report an account for each trial court's plans as to how it would use the $60 million augmentation that came forward in the Budget Act, which of course we did. Since the last hearing, there have been additional developments. You have also asked that we respond to the question, what will an added increment of funding do in terms of each trial court being able to provide improved access to the citizens we all serve? We immediately surveyed all of our 58 superior courts and received in response to the survey well over 300 pages of response, which we condensed into the summary which you have on yellow paper today. I understand as well that several presiding judges met at length with Chairman Jones Sawyer to lay out the particular narratives for each of their individual courts as to how the stark contrast really comes forward between an augmentation at $100 million versus an augmentation that is based on the chief's budget blueprint. You also wanted a follow-up report and required it to what occurred with the $60 million after we told you what each trial court expected it would do. That report has now also been lodged with this body, and as everyone is aware, the outcomes were very, very similar to the individual superior court's projections. We have, since the last hearing, also made considerable improvement with respect to the cross-pollination of efficiencies that are created on a trial court by trial court basis. Again, as was previewed by Presiding Judge Brian Walsh to Chairman Jones Sawyer, we have created an online knowledge bank into which all trial courts provide efficiencies that they have utilized, which are replicable, so that they can be utilized across the branch as innovations. It's in the form of an app store, is highly user-friendly. We, of course, have provided you with an ongoing list of the different efficiencies on a branch-wide basis that we have sought legislative approval of beyond the 4 that the legislature approved last year. Finally, as I believe everyone is aware, with respect to efficiencies that are sort of in the nature of outside-the-box thinking, changes in statute that could produce greater efficiencies in the way we do our business on behalf of the customers, users, and Californians. The Chief Justice is in the process of formulating what might be called a Blue Ribbon Commission for that purpose. Your staff report and the Legislative Analyst's Office report verifies that this year we face what we've called the treading water problem. Our baseline, in order to avoid the further degradation of services, is $266.5 million for the reasons having to do with uncontrolled health benefit and pension costs to the employers, and for reasons having to do with the previous use of our fund balances, or reserves as they are called, to subsidize court operations to keep them higher than the appropriation would otherwise allow them to be. The staff report also highlights that we have indeed, through the actions of this legislature some years ago, detailed performance measures in place in the form of the delay reduction time standards that were part of the mandate of the Trial Court Delay Reduction Act. And of course, those time standards have produced annual studies on a 10-year rolling basis with respect to each detailed case type as to how the trial courts are performing in that regard. Few things translate more into the issue of access than the time it takes for a litigant from the beginning of his or her case until it's resolved. So respectfully submit that the Trial Court Delay Reduction Act really contains the seminal performance measures as to which, once again, we report and account annually. In fact, this body had as its organizing principle in our budget discussions for our branch access to the public. And the means that this body chose for ensuring that the dollars were spent on enhancing access was the requirement that we report and account to you, as we have repeatedly. We are grateful once again for the considerable support this body has provided in moving our branch back and in enhancing reinvestment in the branch. We are grateful to you for your consideration. We respectfully request that you approve the funding identified in the Chief's budget blueprint, and I thank you.
Thank you. Report from the Department of Finance.
Thank you. Madeline McLean, Department of Finance. I would like to note we recognize that budget reductions have had a significant impact on the courts, leading to reduced hours, staff, closed courtrooms. However, the reductions to other state entities were equal to, or not, if not greater in magnitude. The governor's budget proposes $100 million to support trial court operations, which is an amount that can be sustained given that the state is just beginning to emerge from the recession, and it is unknown if the revenues are of a one-time or ongoing nature. I would like to point that we concur with the LAO's analysis of the ongoing reductions to trial courts and use of reserves to offset the reductions. And we also agree with the recommendation to implement performance metrics as a measuring and accountability tool. However, we believe establishing priorities for funding infringes on each trial court's ability to assess need and direct funding to the appropriate areas. We also agree that the legislature could consider approving additional efficiencies to assist the branch.
I had a question. How are we going to be able to address there's a $67 million fee shortfall? Is there any plan to address that?
Please.
Oh, okay. We've been analyzing the projected trial court trust fund revenues, and we will address this issue as part of the May revision.
Okay, open it up for public comment.
Good afternoon. Michelle Castro with the Service Employees International Union. I want to speak specifically to the issue of the ongoing costs with regarding to employee benefits. The governor's budget summary and the LAO cites it as stating that there are some courts where the employees don't pay for all or a portion of their pension benefits, that the court is picking up those costs. And it kind of infers that this is a rampant problem. And I want to clarify it's not a rampant problem. And in fact, some information we got from the AOC after this comments came up in the governor's budget was that 17 out of 58 trial courts are paying a portion or all of their trial court employees' pension benefits. But what's important to note about these courts is that they are the smallest in the state. The employees are largely non-unionized. There's one exception. It's Riverside Superior Court. When we took a look at that document, we noticed that a couple of the SEIU represented counties were among them. There were 3, and in fact, according to our contracts, the employees are paying the full freight of the employee share. So it's really only 14 out of 58 counties in California. And again, there are some instances where the employees are paying a portion of that pension cost or all of it. So conversely, the large majority of court employees in California who are unionized are paying their portion of their pensions. So what that means is that this is not a rampant problem. It's a small problem that exists for a few very small trial courts. And another note was that there was a question, in fact, whether were courts being responsible in managing their employee costs. What this tells me is that you have the majority of them, the large majority of them, ensuring that their employees are paying their fair share. It means that the employees and the trial courts are being prudent and they are being efficient. So I just want to clarify this for the record. This is not a rampant problem. It is a very small problem in very, very small rural counties where, in fact, what often happens in these jurisdictions is that the wages are the lowest in the state. So the employer often will pay the pension costs as a kind of a way of making up for the salary. And this is cheaper for the employer because the actual salary is less if you pick up the pension costs as opposed to put an equivalent amount into their wage and have the employee pay it, because then it increases the overall pension obligation for that employee. Excuse me. So I just wanted to, again, clarify this because this issue comes up time and time again. And just wanted to be clear. And given that the courts have been prudent on this, and that every jurisdiction in California is facing increased benefit costs, the courts are not an anomaly. So we strongly would urge you to fund the increased employee benefits portion in the judicial branch budget. Thank you.
Thank you.
Good afternoon. I'm Marcia Slough, the presiding judge from San Bernardino County. Thank you for the opportunity to stand here today. I've stood before you on other occasions. As you all already know, we come from a county that is historically underfunded. With that premise, the letter that you all signed and sent to the governor to support additional funding to the court meant so much to us at home, and I can't thank you enough for your advocacy for not only our court, but many other courts up and down the state. I recognize you have a lot of people tugging at your sleeves these days, and I honor that. I get it. And the one place that we all intersect oftentimes is on the steps of the courthouse. So your support means even more, not only to our constituents, but to many of those who come to you for your help. Thank you very much.
Mr. Chairman and members, Robert Height, Presiding Judge, Sacramento Superior Court. First, I would like to thank you for your support in the letter to the governor. We hope that he reads and listens carefully. The governor's proposed budget, as I told you last time, will mean a loss of 30 people in Sacramento Superior Court. In addition, the proposed blueprint of the chiefs will substantially bring us back to providing public service for all of the employees. It will make a drastic difference in the time and speed in which we can process civil and family law complaints and issues, and it is much needed. Thank you very much.
Mr. Chairman, I'm Barry Good. I'm the presiding judge of the Contra Costa Superior Court, and I want to echo what's been said by my colleagues. The letter that you sent, the leadership that you've shown, Mr. Chairman, in helping to reopen access to the courts has just been so heartening to us, those of us who have had to make the horrible decisions about closing windows, closing courtrooms, closing courthouses, have been living with these decisions and the consequences of them for the people we try to serve for the last 4 years. And it's just such a wonderful thing to see that we have champions here now in this body who are willing to help us to restore access to justice for the people who need it. We would look forward to the day when this budget, as you've described in the letter to the governor, allows us to receive domestic violence petitions, elder abuse petitions in our branch courts, enable us to put juvenile courts back where they belong, and enable us to keep counter windows open and be able to serve the public the way we should. Thank you very, very much for your leadership on all of this.
Mr. Chairman and members, my name is Glenda Saunders, and I'm the presiding judge of the Orange County Superior Court. Thank you very much for your advocacy efforts in support of the judicial branch, and thank you specifically, Mr. Chairman, for meeting with us on Monday and being so generous with your time in listening to the specifics of our various courts' needs. Because you have those in writing from us, I won't repeat them. I will simply let you know that the Orange County has survived over the last 3 years purely as a result of reserves. and operationalizing $34 million in reductions. Those reserves no longer exist, will no longer be there as of June 30. We will not be able to draw on them because they will have been spent down. We have cut the fat. There is no flesh left. We are now going to have to cut into bone. Access to justice, as you know, I know because you are advocates in support of access to justice and the judicial branch, is not an option. It's a vital necessity. If people cannot have their rights vindicated, what will they do to have them vindicated? Our country would be a very different one if courts had not vindicated those very rights. Thank you very much for listening to me today.